Hey everybody, it's Dugan Kelley with Kelley Clarke and the Syndication Closer. So thankful that you're here today to listen to me talk about the Corporate Transparency Act. In particular, this is one of the hot issues affecting anyone that owns an entity in the United States today. It's important for you to understand exactly what is the Corporate Transparency Act? Does it apply to you? What should you do about it? What are the penalties if you do nothing about it? And or if do you fall in one of the exceptions associated with this? So I recently spoke on this at a conference elsewhere, and so I thought that this would be helpful for a lot of people out there trying to figure out exactly what to do about the Corporate Transparency Act and how to remain in compliance. So why don't you join us here as we unpack the act? So a little bit about our firm before we get into the actual content. Lawyers here at our firm have been practicing over collectively 45 years. We're licensed in multiple states. I'm licensed in California, in New York, and in Texas. In 2022, I structured over $5 billion in deals in the hard asset space for sponsors, syndicators, operators. I use those terms interchangeably with one another. In 2023, we did over 3 billion plus, and I've written a couple books. That's a little bit about us. If you want to know more about us, I'll give you some contact information at the end of this talk so that you can contact our office to see how we might serve your legal needs, or if you have questions about the Corporate Transparency Act, or you want a copy of our slide deck, we're happy to provide that too. All right, so this is the Corporate Transparency Act, or CTA for short. It was enacted in 2021, but it's basically effective January 1, 2024. So it's right hot off the presses. This requires reporting companies to submit a report to the Financial Crimes Enforcement Network. It's also known as FinCEN, containing personal information about the reporting companies, what they call beneficial owners. These are companies that were formed. So if you formed an entity before January 1, 2024, don't worry. You have until January 1, 2025, unless the regulations change, for the initial report and the filing. There's an estimated 32 million, you heard that right, folks, 32 million entities will have to register. So this is a big act. It's a big requirement for anyone that owns an entity. Certainly when you're buying and selling assets, most people do that through entities instead of their own individual name. If you're acquiring assets and you're using leverage or debt from anyone, almost entirely those people are requiring you to do that business through entities. So you can see why there's a massive millions and millions and millions of entities will have to register. For people that don't register, there is non-compliance. We'll talk about that later in the talk. And there are some proposed regulations that if they go into effect, maybe some of these time periods for reporting might get elongated. And so one of the proposed things is that anyone that forms something in 2024, they would have 90 days as opposed to 30 days. That hasn't been enacted. So right now you've got 30 days theoretically to register if you create a new entity in 2024 with FinCEN. Okay, so Corporate Transparency Act. What's the purpose, right? Well, the purpose is actually a good purpose. It's to enhance the transparency in entity structures and ownership to combat money laundering, tax fraud, and other illicit activities, right? So I have a lot of clients that are privacy buffs, and they are obviously don't want to be filing and recording in public databases, and so they think that obviously there's some issues resolved with privacy. Yes, there's no doubt. Privacy is being compromised in connection with the stated purpose of the Corporate Transparency Act, and that is to combat money laundering, tax fraud, and other illicit activities. It is also designed to improve business activity transparency through the reporting of what we call beneficial ownership information, BOI for short, particularly targeted to smaller businesses. So a lot of you that have opened up bank accounts with big banks have had to fill out already. You've already had to disclose some of the same information, to those banks in order to get a bank account. Basically, who owns over 25% or more of an existing entity. Most banks have required that in order to go through that KYC, know your customer, anti-money laundering type of process in order for you to open up a bank account. This will impact, according to the Small Business Administration, over 27 million entities that are right now small businesses inside the United States that will actually have to register. Who needs to file, right? So we know what the purpose is, but now we're going to talk about who really needs to file. Well, domestic reporting companies, LLCs, corporations, limited liability partnerships, limited partnerships, or any other entity created by the filing of a document with a Secretary of State or any similar office under the law of a state or Indian tribe. So it is the broadest possible definition of who actually has to file. And then foreign reporting companies, a corporation, limited liability company, or other entity formed under the law of a foreign country that is registered to do business in any state or tribal jurisdiction by the filing of a document with a Secretary of State or any similar office. Obviously, there's an exemption for sole proprietorships. Not using single member limited liability companies are exempt from reporting requirements. So if you fall into that limited category just when on this, then you don't have to file, but most people and most of your entities will have to register. All right, so the reporting company, what is that? Well, a reporting company is the legal name, the trade name, or doing business as the name, the current address. This is information that they're gathering up, the jurisdiction of formation. So for example, if you're in California and you formed a limited liability company in California, your formation would be California or New York or Texas or any of the other states throughout the country. The company's employer identification number, that's what that EIN stands for, or foreign tax identification number for foreign reporting companies without an EIN. What type of information are they going to be required to submit for the beneficial ownership information, this BOI? Well, the definition of a beneficial owner, according to FinCEN, is any individual with direct or indirect substantial control over the reporting company. Individuals who own or control at least 25% of ownership interests, including equity, stock, voting rights, and more. I recently saw for another client where they had a non-member manager, like a professional registered agent company that was in control of their entity, and they terminated that relationship with the client because they did not want to have to report or go through the hassle of this aspect of it. I don't think there's anything illicit with not wanting to go through the hassle of it, but you need to understand that if you fall into this category of a beneficial owner, any individual with direct or indirect substantial control, regardless of whether you own equity in that company, you could have substantial control. In my analogy of, I don't want to have any more control because I don't want to have to file and take ownership of that filing process. And so what does substantial control really mean? Well, the definition it will include individuals with significant authority, such as senior officers. If you have any of the C-suite style individuals, like a chief executive officer or chief financial officer, those who can appoint or remove officers, influence key decisions, or like compensation schemes, meaning the compensation that people within the organization actually will get. Multiple beneficial owners are always possible, so substantial control reporting is always required. So just don't think just because you reported on one person that you've fulfilled your duty and everyone and your entity is properly filed. You need to make sure that the beneficial ownership, the BOI, is properly filled out and complied. So company applicants. So what can the company expect? So for reporting companies with two individuals, you're going to have two individuals, the person who directly files formation documents, so that might be your legal counsel or your chief financial officer or something like that, the person primarily responsible for directing or controlling the filing if it is not the same. And so in our example, we have individual A prepares formation documents, individual B files those documents. Both A and B are company applicants in connection with this filing requirement. And here is going to be the required information from both beneficial owners and company applicants. Information for the beneficial owners will be the full legal name, date of birth, current residential address, and identifying number and image from documents like a U.S. passport, a driver's license, an ID card, or foreign passport if no U.S. document is available. Information for the company applicants will be the full legal name, date of birth, current residential address or business address for the entity formation business, identifying number or image of the following same documents. And you might think to yourself, oh my gosh, I have to provide my driver's license or my passport. That seems super intrusive on your privacy concerns. Well, remember the purpose of the Corporate Transparency Act, and that is to stop money laundering or other illicit activities. So certainly being able to recognize with the filing somebody that is not engaged in illegal or illicit activities, they need to be able to tie the identity of the person to an actual number, like your social security number, your passport, or other type of government number in connection with this. So many of you are probably thinking, oh my gosh, that I just don't want to do it, right? Well, there might be a silver lining for those of you that don't want to do it. If you fall into some of these exempt companies based on provided information. And so here's a list, and there's a long list of potential sample entities that might not have to, that will not have to register, and these are exempt. And so when you start looking at these: bank, credit union, deposit institution, holding company, money service business, broker, dealer in securities, securities exchange or other clearing agency, other exchange act registered entity, venture capital fund advisor, commodity exchange, accounting firm, public utility, you can start to see that these are entities that have already provided information to other government institutions because they have regulated licenses in large part to provide the services that they do to the public, if you will. So the government isn't requiring them to file because they've already essentially filed. They've already provided sufficient information to allow the government to feel confident that they're not engaged in money laundering or other illicit activities to accomplish that purpose for what the Corporate Transparency Act was designed to do. And so here's a little bit more about like a securities reporting issuer. If you fall into that, governmental authority, these are exempt entities. A bank, further, credit union, deposit institution, holding company, money services business, broker, dealer in securities. Remember, these are all specialized entities that provide services to the public at large, and a part of that licensure or them forming their business and being allowed to be able to conduct business, they had to actually go through a vetting process. In large part, many of these require criminal background checks, fingerprints, providing of birth records or other types of documentary evidence that essentially is able to prove up exactly what the Corporate Transparency Act is already designed to do. Public utilities, financial market utilities, pooled investment vehicles. If you're a syndicated entity, that's not what they're really talking about here. What they're really talking about would be bank, credit union, broker, dealer, and securities, investment company or investment advisor, venture capital or fund advisor. So if you're a syndicator, operator, sponsor that bought, let's say, an apartment building or something like that, or a self-storage building or a mobile home park or something like that, are you going to have to register your syndicated entity or even your manager entity, your general partner entity if you're doing that? The answer is yes, you will. That does not fall into one of those exemptions. Tax exempt entities, 501c3s, those types of things, entities that exist in tax exempt, and these large operating companies that has basically an entity that employs more than 20 full-time employees in the United States with full-time. Remember, payroll records and things that are already filed, tax returns that are already filed with the government, that helps the government establish essentially some of the same things that they're looking for in connection with whether they are exempt or not. And they've determined, obviously, after extensive dialogue and the passage of the Corporate Transparency Act, that some of these entities are. So inactive entities, what if your entity is inactive? Well, any entity that was in existence on or before January 1, 2020, and it is not engaged in active business, is not owned by a foreign person, whether directly or indirectly, wholly or partially, has not experienced any change in ownership in the preceding 12-month period, has not sent or received any funds in an amount greater than $1,000, either directly or through any financial account in which the entity or an affiliate of the entity had an interest in the preceding 12 months, and does not otherwise hold any kind of type of assets, whether in the United States or abroad. So if you fall into that category, you don't have to file either. I would encourage you to talk with your legal counsel, your certified public accountant, before you unilaterally make a decision on whether you are exempt or not, because the penalties are very stiff. And if the government decides that they want to audit and or determine that you were required to file, ignorance of the law is not going to be a defense, nor is the inability to do it or the feeling or good faith belief that you thought you were exempt when you were not. So why should you care, right? Well, remember, the government, Uncle Sam, is watching, and every step you take, I will be watching you, right? There's a little pun here, but the reality is that in order to require compliance, specifically with the purpose is so great to stop illegal activities and to provide transparency in connection with a lot of these businesses that take place. The government has fairly stiff penalties associated with this Corporate Transparency Act. So the willful failure to report or to update the beneficial owner's information, here are the penalties. So it's civil penalties, a daily fine of $500 for each day for a continuing violation with a maximum cap of $10,000, or criminal penalties, if it was very severe, up to 2 years of imprisonment. I think I've got this noted down here. It's very important to note that the Corporate Transparency Act does not include provisions for non-willful or negligence-related penalties. That would be something like I just forgot, or I never heard about it, or I was traveling for a long time. And what's this all about? Or I'm not into podcasts or consuming this type of content. Nobody ever told me that I had to do that. Those types of things, they haven't come out with this with a penalty scheme. But if you were stuck with $500 per day up to $10,000, that's a very stiff penalty. So you want to make sure, again, seek counsel and advice before just disregarding any obligation in connection with this. So what are the changes in the timelines that you need to be aware of? Well, changes to your beneficial ownership information, updates are required within 30 days of any change. So to the extent that you're selling off a big chunk of your entity and so doing, that's going to change who actually has control, or you're bringing somebody else in who will also share control with you. those are material changes that would trigger an update requirement from you in connection with the Corporate Transparency Act. Example of changes require an update: reporting company details, new DBA registration, right? Beneficial ownership changes, new CEO or a sale altering at least 25% of ownership, or the death of a beneficial owner, address, name, or unique identifying number, like your EIN changes for beneficial owners. This is important that that you think about this. That they're literally like any number of scenarios that might trigger an update requirement in connection with this. Note, and I have note here: report changes due to a deceased beneficial owner when their estate is settled. Include any new beneficial owners if applicable. Update if a beneficial owner obtains a new identifying document. So, and you have 30 days. So just remember 30, 30, 30, 30. Those are kind of the timelines that you really need to do it. I love this quote by Calvin Coolidge: nothing in the world can take the place of persistence. You're certainly going to have to be persistent, resilient in responding to the Corporate Transparency Act. Talent alone, or just this idea that you're going to be able to withstand or avoid this thing, is not going to happen. So you need to make sure that you're paying attention and that you're going to be able to process this information and act accordingly. Here's another quote from Calvin Coolidge: education will not. The world is full of educated derelicts. Persistence and determination alone are omnipotent. So when we're talking about things like this, press on, the slogan "press on" has solved and always will solve the problems of the human race. So I think that is one of the greatest models, especially if you're like not another bureaucratic change. If that's your mindset, well, then I would just encourage you to press on, because it's required, and and just add it into the kind of, this is kind of the cost of doing business. So if you're somebody that you think that might apply to you, and it's really anyone that has a business that existed before 2024, or anyone that's starting a new business, it's something important for you to remember. If you like this content, you like this video, and you want to follow us, please like or subscribe our page. You can follow us on Facebook, on YouTube. We're on, there's our telephone number as well. You can contact us at our Prosper, Texas, or Santa Barbara locations. And there's my email if you want to hit us up with an email. I hope this content was helpful for you. Please stay tuned, because we'll create some more stuff at a later date. God bless you. Happy hunting.